Good afternoon, folks. This is Dick Powers and the Venable team. With me are Fred Wagner and Rich Ward. This afternoon, we'll be giving a presentation on energy and environmental policy under the second Trump administration. To begin with, though, I first want to have each of us introduce ourselves to you and our backgrounds, and then we'll head into the program. First, I'm Dick Powers. I'm the head of the Energy Practice Group at Venable. I have been at Venable for about 20 years. Originally, I started off practicing law in Texas. As you can see behind me, I have a Texas flag. I grew up in Williston, North Dakota, in the heart of the Bakken. And my family was in the oil and gas business for many, many years. In practice in Texas, I was in the oil and gas area, traditional and conventional oil and gas. And then I moved around from various sectors, including natural gas, oil and gas, international, did some hydro, did some power, have been at Venable doing mostly a wide range of judicial, administrative, and legislative and some transactional matters. So we've seen quite a bit over the years, including starting it off with the Carter administration when we had the Natural Gas Policy Act, when we moved from there to the Reagan administration. So I've seen quite a bit of transition. Nothing quite like this, but I'll let Fred and Rich introduce themselves and then we'll start.
Thanks a lot, Dick. I'm Fred Wagner with the firm's Environmental Practice Group. Between private practice and the public sector, I've been doing environmental law for almost 40 years. I started my career at the U.S. Justice Department Environment Division and also served as chief counsel at the Federal Highway Administration at the U.S. DOT. Rich?
Thanks, Fred. Thanks, Dick. Richard Ward, I've been at Venable almost a year and a half. Prior to that, almost 11 years at the Edison Electric Institute, working on a variety of energy issues with the electric power sector. And prior to that, worked for Leader McConnell and President Bush in the White House. Good to be with you all today.
We can move on. Let me first start with talking about the shifting energy landscape. Until recently, as you know, the Washington and the Biden administration have used tax credits, tax rebates, direct payments, loan guarantees, spending programs, regulations, and tariffs to move a market-driven economy, especially in promoting the development of clean energy technology with the goal of tackling climate change. During the Biden administration, the government was a big player in influencing what was produced, where it was produced, and what labor was used. They passed things like the Inflation Reduction Act, which was known as the Climate Bill, which had about $369 billion or probably more in security and clean energy provisions. The law focused mostly on renewables, solar, wind, hydrogen, EVs, and so on. Goldman Sachs at the time called it a, quote, game changer for clean hydrogen economy, for the clean hydrogen economy. They focused on the IRA and investment tax credits for solar, for hydrogen, and so forth. Well, times are changing. I think one of the more interesting comments I read was by the Energy Secretary Wright when he described the Trump administration's energy plan or policy. He said, quote, "The administration has a simple vision. Energy was good and that we need more energy, and in particular, more American energy." I think that pretty much sums up what we have in the Trump energy program. The demand for energy is growing not just in the United States, but it's growing worldwide. Here, recent demands for AI are growing exponentially. Here, the electricity grid is being pushed to its limits. And today, worldwide, current energy technology has allowed about 1 billion people to live comfortable lives when there are about 7 billion people that aspire to the same lifestyle. That means one thing. We need more energy, more electricity, more secure energy, and more affordable energy. Many of you may have seen in last month's or this month's Foreign Affairs an article by Daniel Yergin and others called "The Troubled Energy Transition." In that, they point out that over the last 15 years, wind and solar have grown from virtually 0 to 15% of the world's electricity generation. In 2024, the share of hydrocarbons in the global primary energy mix hardly moved from 85% in 1990 to about 80% today. The amount of energy derived from oil and natural gas and coal hit an all-time high. What they point out is that we're really in a world of energy addition and not energy transition. Energy transition suggests that we're replacing most of today's energy systems with a completely different system. However, that's not a reality. Rather than replacing conventional sources of energy, the growth in renewables is coming on top of that. This is largely because we need every conceivable form of energy to meet current and future demands. And with Donald Trump's return to the US presidency, priorities will shift. They will focus on conventional energy production and what his administration calls energy dominance. The new administration not only aims to make the US independent on energy, but it also seeks to be a preeminent provider or exporter of energy worldwide. You see on the screen, there's a few slides that this talks about the energy demand and the grid. It also points out that they're de-emphasizing quite a bit the push into quite a bit, if not a lot, into the clean energy area. This driving forces behind this administration appear to be energy for all from traditional sources, and you'll see that they're removing barriers, or they propose to remove barriers to development of conventional energy. With that, I'll pivot and I'll let Fred talk about the environmental landscape.
Thanks a lot, Dick. The folks expecting changes in the new administration probably didn't even expect the quantity and the scope of changes that we're seeing and that we will see. And that's the overarching theme that I want to stress for environmental law and policy moving forward. It is truly hard to overstate what it's going to happen and the changes that are going to be implemented at every level, at the US EPA, at the Department of the Interior, the US Army Corps of Engineers, NOAA, and every federal agency that touches on environmental issues. The executive orders that we've seen so far, that we're going to talk a little bit during the webinar here, that's just the tip of the iceberg. And as we say here, the other regulatory shoe is yet to drop. And a lot of the orders to the EPA and to the other agencies to review regulations, to review staffing, to review priorities, all of these are reports that are going to be made and implemented over the next coming months. So you have general sense of what's going to happen, but really the other shoe is going to drop, and it's going to drop pretty soon. Almost equally important than the executive orders are the administrative actions that are being conducted here throughout the government. And these involve staffing cuts. They implicate funding, the freezes of funding that have been ordered so far, the review of funding that's been ordered, as well as I predict there's going to be a tremendous difference in terms of the oversight on states and what individual states are going to be allowed to do, depending on who's running that state, whether that state's being run by a Democrat or a Republican. And ultimately, as Rich is going to talk about here in a bit, we expect Congress to have its say. They're not going to be bystanders in this, and they can do so in a couple of ways. We're expecting a spate of activity under the Congressional Review Act. There's already been at least 24 resolutions proposed for regulations that are maybe up for rescission, revocation by a simple majority vote in the House and the Senate and approved by the president. And those are going to continue to be introduced and reviewed and eventually started to be voted on, I think, as early as next week. There are other initiatives, I think specifically focused on permit reform and additional work in the world of NEPA, which we're going to talk about. And then finally, all this, and this is, again, I can't overstate this enough, every step along the way, Dick, of the things in the environmental world are going to be subject to litigation. There are going to be challenges by folks who don't like it. There are going to be challenges from state AGs, just like the state AGs have been challenging some of the funding freezes. And with respect to some actions like the endangerment finding, which we just read about this morning, that a recommendation from EPA to the White House to rescind the endangerment finding for carbon that dates back to 2009. If that is proposed, that will have litigation that I predict would go through the entire 4 years of this administration. So stay tuned, a lot more is to come, and I'm going to give you examples of all this as we go through the slides. Rich?
Thanks, Fred. And the shift in energy policy and environmental policy is all with the backdrop of going from relatively flat energy demand for the last few decades to what is just becoming now a rocket ship straight up. And we all read about these every day, but the fact that policymakers now have to factor in how they're going to manage this demand, along with how industry is going to manage it and how it's regulated in the states, all while dealing with ensuring energy generation and electricity remains affordable and reliable. And so we're at a real crossroads here as policymakers have to deal with these issues. We know what AI and data centers are going to bring. There's a lot of debate on how much energy demand, but as we're going to see use of AI increase, we expect the energy demand to follow along. We have been focused on electrification from before AI, and that is still around, and we'll still continue to see growth. And then obviously how we handle different impacts from the climate, whether it's heat or cooling that is required to keep folks comfortable in their homes and places of work. And so we have all these issues converging at the same time that we're dealing with a pretty big shift from administration and now a Republican controlled Congress aligned with the White House, though with small majorities. And so how they handle all these is what we're going to sort of walk through right now, pivoting back to what President Trump is going to has started to lay out with the executive orders, and I'll hand it back to Dick.
Thank you. Before we start into it, what we tried to do in the next slide was to slim down into 5 really bullet points what we thought the administration was doing on energy. This is hard to do, but I think we ought to look at it. We drew this from the executive orders and the actions that have been taken so far. First one, rescinding existing and limiting new regulations that interfere with the development of domestic energy sources. We'll see that themes throughout. And then secondly, opening additional American territories for energy and mineral extraction. That counts the offshore areas as well as Alaska. Next, imposing tariffs on foreign energy imports in order to protect and foster domestic energy development. Next, exerting additional authority, and this is a big one that Fred has talked about before, over regulatory agencies, independent agencies, to ensure that the agency has a consistent view with the Trump administration policies. And then finally, and I talked about this to begin with, eliminating prior orders and regulations concerning the implementation of the Inflation Reduction Act and the bipartisan infrastructure law, especially those concerning the development and subsidization of clean energy. And we saw yesterday that the House passed their budget, I guess you would call it reconciliation bill. I don't want to step into Rich's area, but the thing that drew my attention was the reduction they were requiring the Energy and Commerce Committee to make, which was $880 billion. That comes out of Medicare, Medicaid, and oh yes, energy. So that puts under the focus, under the scope, things like the IRA and the bipartisan infrastructure law. With that, let's turn to the structure. I'm going to talk about the structure of the rest of this program. For simplicity, we thought the best way to do this was to talk about the executive orders first. And then after the executive orders, we'll talk about some of the administrative agencies, Department of Interior, Department of Defense, EPA, legislation. Rich will cover that. But for the executive orders on this slide, we lumped them in, I have lumped them at least into 4 categories. The first 4 of which I consider the policy executive orders that outline what the Trump administration wants to do. Unleashing American Energy, rescinding Biden orders, the National Energy Emergency Order, and the National Energy Dominance Council, which includes almost every agency in the government. And a separate kind of sliver of executive orders relates to the tariffs. And as you've heard, the tariffs on Mexico and Canada and even on China. And the last couple slides or couple executive orders deal with the interactions between the executive branch or the administration and the agencies. And we'll focus on those. And after we get through those, we can talk about individual agencies a little bit. But I hope through this discussion in each of these, we will bring into play the agency. So that's the sort of order we're going to follow. Each of us will have comments on the slides as we go. So let's head down the road and look at the first slides that have to do with unleashing American energy, the National Energy Emergency, and the National Energy Dominance Council. I think the biggest order and the longest order is the first one we have here, which is called Unleashing American Energy. And this was signed on January 20th. And it's, quote, in order to unleash America's affordable and reliable energy and natural resources. And according to that, the policy of the administration, and it lays out several things. We have highlighted here about 6 of them: exploration on the Outer Continental Shelf, the production of non-fuel minerals, critical minerals, the focus on economic security, national security, and military preparedness. And you'll see throughout this that the president has called on the various agencies to look at their emergency authorities in order to implement some of the programs that he's putting forth. And then finally, he wants to make sure that all the regulatory requirements are, quote, grounded in clearly in applicable law. The last one you see on this slide, it has to do with the EV mandate. Again, the clear focus is on conventional energy and what the administration calls energy dominance. It calls also for reliance on peer-reviewed scientific analysis. And as you'll see on the next slide, he's asked the agencies to develop a plan within 30 days to suspend, revise, or rescind all agency actions, including existing regulations, orders, and guidance that unduly burden the identification, development, or use of domestic energy sources, especially oil, natural gas, coal, hydropower, biofuels, critical minerals, and nuclear energy. You'll see that list of resources often. And what is notable in that is what it leaves out, what is not in there. I didn't see wind in there. I didn't see solar. This executive order also directs the Attorney General to consider when pending litigation against illegal or dangerous or harmful policies should be withdrawn or stopped. And for any project, as I've said before, that the agency deems essential for the national economy or security, it shall use all possible authorities, including emergency authorities, to expedite permitting. And it also calls for them to work closely with project sponsors.
Dick, let me add a couple of points here. I think a lot of the activity that's come up on this executive order to come is the foundational assumption of an energy emergency. There are going to be, and there are already challenges to the premise of that and the foundation of that for all other regulatory actions. Great example, Dick, is the U.S. Army Corps of Engineers published a list of 600 projects last week that allegedly were going to be fast-tracked because they were related to the energy emergency. A couple of days later, they retracted it and they changed it. But the point is, it all relates to that foundation about the energy emergency, and there are going to be challenges to that as we move forward. So I want to flag that for the audience because I think that's going to be where a lot of the action is going to be on the legal front. Second thing is the regulatory review. One of the executive orders that we'll talk about a little bit that was listed earlier also relates to this executive order, and that is the grouping, the listing of regulations that every agency is going to submit to OMB for potential review, revocation, and changes. And that's coming up around April 19th. So between now and April, all the agencies that are touched by this executive order, the typical ones which we're going to talk about, Interior, EPA, the Corps, etc., they have to submit that list by April 19th, and it's going to be a robust list. So I just wanted to say, from a practical perspective, the implementation of some of these objectives are going to come out that way, and then the litigation is going to focus on, is there an emergency here, and are these actions justified under that emergency finding?
And I think I would just add, I think you're going to see Republicans in Congress do as much as they can to codify these objectives as they work through legislation and reconciliation, whether it's on offshore drilling or permitting reform. You're going to very much see to make some of these things permanent, to where an executive order is not in statute, and therefore, you know, another president can come along and change these things. But if they can do that, they can kind of create a legacy for President Trump in terms of what he's trying to accomplish on American energy.
I think that's great. And we'll also see later on, Fred, when we'll talk a little further about the national emergency. Before we leave this slide, I only want to make one other point. The first bullet on this talks about doing something within 30 days. This has already cost a little flap on the hill, because yesterday, I think it was, Senator Heinrich on the Senate Energy Committee and Congressman Huffman, they're both the lead in the minority in the House Natural Resources Committee, sent a letter over to Secretary Burgum asking him for his plans, what he's doing here, because he hadn't seen it yet. So this is going to be a lot of back and forth between the administration and certain parts of Congress. We can go to the next one. This one is about clean energy initiatives after this. We've already seen a lot in the press where they've paused payments, they've paused loan grants, they've paused implementation of certain regulations. They've been hit with a TRO in the district court before. I think it's important here to realize that there's a difference between a pause and elimination. The fact that they paused it doesn't mean that that funding or that grant has gone away. But it does make a number of our people concerned about their existing grants and contracts. And I know that you've probably looked at that before, and we fielded questions about what impact this is going to have on existing contracts, especially those that haven't been funded. And with that, I'll pass to the next, unless you guys have more comments.
Well, just quickly to note that, you know, perhaps the one that's gotten the most news in the environmental space is the pause of the $20 billion greenhouse gas reduction program that came out of the Inflation Reduction Act. That ended up being Administrator Zeldin's first priority after he was sworn in, and orders went out, and it became pretty clear that the entities that had been granted that money did not have access to those funds, including Citibank. So this was not just like a small entity. Citibank couldn't get access to those funds. So the litigation that Dick referenced is going to have ripple effects across the government as different courts struggle with pause versus elimination versus clawbacks versus total rescission. And all this is coming out on a day-by-day basis. So if we did this webinar tomorrow, this slide would probably be different, is the bottom line. But that's okay, because we're following it. And it's enough to say that, you know, we just have to be cognizant of what the judges are saying. And as those rulings get then moved up to the appellate court, and then ultimately by the U.S. Supreme Court. And I hate, you know, I wish I could say that's not the case, but that's the case. It's going to happen over the course of the next year.
Yeah. And then we get to the point that we've talked about a little bit, and Fred had talked about a little bit before, and that's their rescission of existing prior administration orders, including the implementation of the energy and infrastructure provisions and Inflation Act. and provisions related to the Clean Energy and Jobs Federal Sustainability Order. This has already had some ripple effects, as I would say, at the agencies, including FERC, because there was a case that went to the DC Circuit for the city of Port Isabel involving an LNG facility that found that FERC didn't properly do its diligence environmentally, and it vacated that order. Well, because the CEQ pulled back, and Fred will address this maybe later on, their NEPA regulations, the administration has now gone to the Court of Appeals and said, you should pull that vacation because those orders that are no longer there. The basis for that decision, environmental justice considerations, are no longer there. So this is going to put a big battle on between on environmental issues before many agencies, including FERC, because with NEPA regulations being, pulled down, every agency, including FERC, has its own NEPA CEQ's regulations being pulled down. Every agency has their own NEPA regulations. The big question is going to be, what impact is the CEQ's action going to have on FERC and other agencies? Right now, as I understand, the agencies are going to proceed as they will on their existing regulations, but there will be a lot of litigation, and Fred can speak to that if he'd like to.
Yeah, no, this is the one shoe that's already dropped. Remember, I talked about the shoes that are covered. This shoe dropped, and the reason it did is that it's just all a matter of timing. Like everything in life is timing. Well, in this case, there were two cases that questioned the authority of the Council on Environmental Quality to issue regulations at all. One was in the DC Circuit called the Marin Audubon case, and another case was challenging the NEPA Phase 2 regulations in North Dakota. The DC Circuit issued a 2-to-1 ruling saying CEQ never should have issued regs in the first place. They didn't have the authority. That was appealed en banc. The DC Circuit said, we're not going to hear it en banc. But in the interim, a judge in North Dakota, you're all home, Dick, you're all home. Maybe you know this.
Yes, that's right.
Issued a ruling saying, you know what? The DC Circuit was right. CEQ never had the authority to issue the regulations, and the administration rescinded a Carter-era executive order that said CEQ should write regulations. And then the administration said, well, you know what? We're going to leave this to each individual agency, Dick. That's their strategy. They're trying to give maximum flexibility to every agency to do their own thing when it comes to NEPA. And, that's going to create a lot of confusion. They also recommended that the agencies refer back to the 2020 Trump rules, the version of the CEQ rules, as guidance for how they should be rewriting their rules. So a lot yet is to come. The agencies have 1 year to redo, revise, update, or in some cases, write from scratch their regulations. And Rich, I know that on the Hill, there's also energy and momentum on this topic as well.
Oh, 100%. And we can talk about it now or
might as well do now.
Yeah, I mean, we just had a hearing in Senate EPW last week to sort of re-kick off permitting reform discussions. There's just a lot of focus on harmonizing and making corrections, particularly to NEPA, that was never intended to sort of slow down these projects like they have of late. And there is bipartisan consensus here to find a deal, as sort of both parties have started to come together, with Republicans saying we really need to be fuel agnostic, and Democrats realizing we can't get our clean energy projects through either without NEPA reforms. And so there is really a deal there. It's just going to take a little time. They were close last year, but anytime you have a presidential election or lame duck, other factors come into play. But that is certainly tippy top on the list, and we will continue to follow it and see how it tracks with how the administration is now dealing with pulling back on the CEQ authorities. But that's going to be a big move by Congress, and big debate. I don't think it's possible, but we may see them try to work it into the reconciliation process, but they'd have to get super super creative. So I don't know that that's going to happen, just given all the other challenges they're having with the reconciliation process right now.
So Dick, this is the most important part of the program. Are you gonna give the Sealy code or am I?
I think, Fred, go ahead.
It's environmental 2025, lowercase e, environmental 2025, one word. We'll repeat it when we get close to the end as well. Go ahead, Dick.
All right. With that, we can flip to the next slide, which we've already touched on with the National Emergency Declaration. I just want a couple things to focus on here. It tells the agencies to look for any lawful emergency power to get these things done, the siting, permitting, and so forth. And the EO states that the United States has insufficient energy production, transportation, refining, and generation, and that constitutes an unusual and extraordinary threat to our nation's economy, national security, foreign policy. In light of these findings, I find there's a national emergency. One of the interesting things I said about this order and most of these others, they define energy and energy resources to mean crude oil, natural gas, least condensates, natural gas liquids, refined products, uranium, coal, biofuels, geothermal heat, the kinetic movement of water flowing, and critical minerals. I have nothing more to say on this one. Fred, I think, said a lot before. Oh, this is another slide. This is on their National Energy Dominance Council, which they set up to have the Secretary of the Interior chair with basically all the departments, defense, agriculture, transportation, participating in this council. The end goal of this is within 100 days of the order, the council must, quote, recommend a plan to raise awareness on a national level of all matters related to energy dominance. This will include the technological improvements and jobs it creates, its importance to the national security, and the regulatory constraints driving up the cost of reliable energy. And it says the council will review energy markets, recommend incentives to attract and retain private sector energy production investments, and identify and end practices that raise the cost of energy. That's a broad overview of what this what it does. It's going to be interesting to me how they implement this, because there are, in developing any energy policy, there are going to be conflicting priorities. Not even all segments of an industry are going to view something the same. So how they deal with that, how they deal with international matters may be something to consider. For example, we have requirements for LNG on methane and so forth that are applicable in the United States. Europe has a different set of standards for various things, including methane. So that means if we're producing it to US standards, it might not be acceptable in the European Union. Well, if that's the case, will we just forget that market, or do we try to work something out? So I see there's some issues that they might want to deal with. Another issue that has come up at FERC and deals with electricity recently is with the interaction of state and federal when it comes to expanding loads. And there's a line between what's jurisdictional to the state and what's jurisdictional to the feds. So what this council actually does and comes out within 100 days will be something to follow. I don't know, Fred or Rich, if you have any further comments on this.
I think I would just add that I think we're seeing the most interest around this council, and we don't really have a lot of information to go off of other than what's been issued in the executive order on the 14th. And so there's a lot of interest in how the council will be set up, not only to coordinate across agencies, but what level of input will the private sector have as they take this comprehensive approach to an energy strategy where everyone wants to get their priorities, in the minds of these folks as they put it together. I think it's a good thing in the sense that we have one place to go, and we know that in the past there have been a lot of issues interagency fights over these issues. And so if there is a place now where we can kind of work through these issues, it'd be interesting to see how they move forward, because, Dick, as you said, there are overlapping priorities. But my experience with industry is we're often caught in interagency fights, and maybe this is a place that can kind of smooth those out and keep things moving.
Yeah, and Rich, what I'd add to that is that I think the reality of staffing and cuts to staffing is going to run headlong into this. Just as we got on air, article was published where the president represented that Lee Zeldin said that 65% of EPA staff would be let go pursuant to their directives to review efficiencies in the government. What I think that means, and that's going to be repeated at these other agencies. And Rich, what I think that means is that entities like this council are going to drive up the decision making to the top of the pyramid, meaning the secretary offices, the White House, the Domestic Policy Council, because there just aren't going to be the day-to-day staff people to do this work. There's just not going to be staffing to do it. And so what you're going to see is a much more centralized decision-making mechanism, and this is one way to do that. So is it efficiency, or is it command and control? Is it the heavy hand of the federal government, or what is it? And that's what we're going to see play out over the next year as these cuts take place.
Well, and I think, the experience of the first Trump term was they really didn't have a handle on these agencies, and there's clearly a lack of trust. And so as they try to manage this, I totally agree. And actually there was a question in the chat. I know we're going to get questions later, but just referencing Administrator Zeldin's comments on the staffing, and I agree. It's going to happen across a lot of these agencies as the secretaries and their political staff get into place and really look at these top down. But something like this allows them to continue with their agenda in a more nimble way.
Yeah, excellent. And one of the last thing before we leave this, I note that one of the focuses, it says they focus significantly on increasing electricity capacity, facilitating approvals for energy infrastructure, and approving construction of natural gas pipelines to or in New England, California, and Alaska. I'm sure California will be happy. I'm just kidding. So,
it'll be really interesting to see how, those are some of the stickiest issues. And so how this Energy Council has sort of the authority to do that. I think you are going to see a lot more natural gas built. The constraint will be on pipelines, which has been a sticking point for a variety of reasons. And one pipeline is never enough when you talk about resiliency and redundancy. And so that's going to be a real challenge.
And transmission.
Transmission is a sticky point too.
Yeah, and one of the things, and I don't want to jump ahead too much, but we're going to talk later on about the order that requires certain things to flow through the White House and OMB, administrative decisions and actions. Okay, they basically talk about agency actions and regulatory actions in particular. I'm sort of presuming, but don't know. And FERC was sort of, when it talked about it the other day, uncertain. Is that going to apply to contested proceedings? Some of the stuff that you're talking about in terms of building pipelines and getting permits is not in a rulemaking proceeding. It's in an individual proceeding. And if it's in an individual proceeding, and I would think it would be very complicated to send that through OMB or OIRA. So I think issues will come up that they'll have to deal with over time. I think we can move. That's the same thing. We can go to the next slide. We're on another topic. This is tariffs. There's been a lot in the news about this, and I suppose we don't need to talk too much about it. This is the on again, off again tariffs. They were proposed, as you all know, and especially for Canada and Mexico, on February 1, 10% on energy or energy resources. They were drawn down until March 4th, more or less. And recently, the White House has indicated they're going to impose them at the end of that period of time or in March. Some, I guess, interesting questions arise out of that because there's obviously a close relationship between, for example, Canada and the United States on energy. And what I see, for example, the United States sends a lot of diluent, which is in two different pipelines that go from the United States up to Canada. And it's used to blend heavy Canadian oil, which is then sent back to the United States. So we send diluent up, it's blended into heavy Canadian oil, transported back to the United States. And under the current proposal, as I read them, that 10% is going to apply to that whole flow of crude oil coming back into the United States. So that's an interesting phenomenon, especially at the same time when we want to get the Keystone Pipeline built again. So when you look at these tariffs, one wonders, what the purpose of them is. Are they leveraging something? Are they for revenue purposes? Time will tell. But they not only affect Canada and Mexico, they also affect China, and they could impact our power system because our grid, the transformers we have, are only about 20% or so sourced in the United States. About 32% of the low voltage transformers are produced in China, and about 36% of the high voltage transformers are produced in Mexico. So this is another area where there's going to be some interplay between other things going on in the administration. So I'll leave it there and let you guys make comments as you might.
Dick, I would just say, this is a balance because President Trump is obviously trying to bring domestic manufacturing either fully back or near shore, and how these tariffs are, will either force that, or he's obviously trying to demonstrate tax incentives if you move your manufacturing facility to the U.S. But all this stuff takes time. And so the current sort of power sector supply chain is very reliant on other countries. And so that shift, which is a good goal, how will that line up with having to dealing with these tariffs from other countries as they import this equipment or critical materials is going to be a challenge to navigate. With ultimately the goal of trying to speed it up to bring it home, there's certain realities with the challenges of that, given that some of this stuff's already in short supply and is critical, and we go through a lot of this type of equipment or require it, and there are obviously economic and national security implications as well.
Yeah, I agree with that. I think it will be interesting to see how that unfolds. We can move on. I want to get through some of these. The next slide. This is the one I think we've talked about a little bit before, and this is basically requiring all agencies to funnel significant regulatory actions through the Office of Information and Regulatory Affairs. And out of that, probably the most notable part is where it requires the Attorney General's opinion on questions of law to be controlling on all employees in their conduct of their official duty. And an executive branch employee cannot, quote, advance an interpretation of law as the position of the United States that contravenes the president or the Attorney General's opinion on a matter of law, including but not limited to the issuance of regulations, guidance, and positions advanced in litigation. Again, how this will be implemented remains to be seen. It applies in rulemakings. When you listen to Commissioner Christie, who's the FERC chairman, the other day on his interpretation of this, he did not necessarily think it applied to contested matters, but it was a question he was going to take back. This accountability issue also raises the question of removal for cause, which we see being played out in the DC courts right now with the NLRB chairman challenging it. And that could have implications for all the independent agencies who have chairman or commissioners who are appointed and can be removed for cause. So this ensuring accountability provision, there will be more to be seen in this.
Yeah, Dick, I'd like to speak to the next slide here. I mean, this is the sort of the premise of the authority of the different agencies to review conduct their review of existing regulations. And, you know, I dare say that those, you know, 7 bullet points there, starting from unconstitutional regulations down, are, I mean, that's so broad you could drive a truck through it. I think we'd all agree, right? There's, you know, it's hard to imagine a potential rule that could be subject to review under an agency that couldn't fit one of these categories. And so the only thing that I think is going to restrict the number of regulations that end up being on the cutting room floor or proposals for review under notice and comment, it's just time. You know, when I was general counsel at FHWA, Dick, you know, the notion was, how big is the pipeline? Everybody didn't want to get the regulations through. Everybody wanted to get them through OMB. But we always heard back from the general counsel, and then we heard back from the folks at OMB. The pipeline's only so big. Well, the same holds true for deregulation. The pipeline's only so big, and the process by which they get noted and then reviewed and comments and then acted on. So the scope of what can be eligible for review under these categories, I would argue, is unbelievably broad. But the reality is what they choose to do, it at some point is going to have to be somewhat more strategic, because there's only so many days in the week, and there's only so much room in that pipeline.
And they're also going to have to presumably, respond to and comply with the requirements of the Administrative Procedure Act when they withdraw or change or modify regulations, which only adds to the time in which all this stuff can be done.
Correct.
And then at this point, I don't know if you want to address it, but when it comes to when you're talking about regulations, one of the things that they talk about is the Congressional Review Act. And I know, Rich, you were going to talk about that later on, but it just struck me that maybe here might be time to do it, because I see that the House has even started a process where they're going to look at the EPA's methane rule and the DOE's efficiency standard rule and use the Congressional Review Act to disallow those, which means they can't come back if it passes in that form or a substantially same form anytime soon.
Yeah, Rich, do you want to start on that, and I'll jump in, or no?
I mean, I think you covered. I'm just looking at the time. I mean, I think you covered that Congress is going to CRA anything that they possibly can from the last administration within the window. And Fred, you could probably describe sort of the dynamic of CRAing something versus letting the administration tweak it and the impacts and the effects on those rules.
Yeah, exactly.
Water heater and methane, and I think there are a couple others that we'll see.
Yeah, the EPA pipeline, the EPA pipe rule, replacing lead pipes, that's going to be high on the list, I think. Some TSCA rules, there may be some endangered species endangerment findings that'll be on that list. Look, a couple things to remember about the CRA. It's limited in time. It's just the stuff that came at the very end of the administration. The date that I think that Congress came up with, Rich, was August 16th of 2024.
Yeah.
Okay, that's
It
the
was
date.
60 congressional days.
Yeah, whatever the congressional days was, that's the date they came up with. Then a resolution has to be introduced one at a time.
Yes.
One regulation at a time. And then that's up for a vote in the House and the Senate, and a simple majority prevails. And then if the president signs it, that's it. The strategy point, though, is that if they rescind that regulation, they can't go back and do something substantially similar. So if there's a notion at all of regulatory relief in a particular program, it could be that the administration could tell their sponsors in Congress, please hold back. Please don't bring such and such to the floor because we want to deal with it. That's why I think like the lead pipeline is such an easy candidate, or the efficiency standards, because the administration doesn't support it. There's nothing else that they would ever plan to do about it. And so if those regulations went away, there, from their perspective, there'd be no muss, no fuss. But if there are other standards like dealing with typical, ongoing compliance and regulatory issues, like the definition of waters in the United States, like hazardous waste rules, they may want to do more stuff. So in which case they may want to hold back on CRAing, as you put it, those types of rules. But the votes are going to start next week. Next week,
Right.
So start looking for them. And Dick, our firm is publishing about once a week an update on all the resolutions and those votes, so the audience can track them.
Needless to say, Fred, there's going to be a lot more going on and a lot more strategizing on the Hill and elsewhere.
You
Well,
think?
All right.
When Fred, we saw, something that you said the other day that untested. I know there's been a lot of focus on the California EPA waivers,
Right.
and waivers, as far as what has been looked at previously, would not be subject to CRA, but we're actually seeing a roundabout with Congress bringing them up to then shoot them down. I guess maybe you could talk a little bit about that.
Yeah, no, and that's going to be another subject of litigation. So the ongoing assumption for years has been that the California waivers, which leads to the EV mandate executive order, remember that bullet point that Dick, you pointed out, were not subject to CRA because they weren't even regulations. And the GAO wrote an opinion saying, that's right. They're not regulations. They're a different type of animal because they're born out of a statutory authority that's different than a regulation. But I think the majority in the House, Richard, I think they're willing to test that.
Yeah.
And
Oh,
so
absolutely.
I think they're going to put it on the list. They're going to take a vote, and then it's going to be up to the great state of California to challenge it, and then to see if that GAO logic was right, if it was wrong, and that's going to be in court, I predict, by the end of this year.
Yeah. All right. We only have one more executive order, and I don't think we have to say much here. This is just their effort to replace, 10 rules with one. In other words, you're going to have to eliminate 10 for every new regulation put in. Question is whether this applies to independent agencies. And quite frankly, I wonder, should it apply equally to all agencies? Not all agencies issue as many rules, but it is there, something to be aware of. Then the last thing we're going to talk about maybe was some of the individual agencies. We can flip through that pretty quickly. I notice we only got about 5 minutes left. So at a high level, the DOE, what I think is interesting, Secretary Wright at his confirmation hearings was very forceful, and he advocated for an all of the above energy approach. So it will be interesting to see how that comes out, especially on things like wind. When wind in North Dakota, for example, is the second biggest wind producer around, behind Texas, I guess. So there are going to be some discussions, I imagine, maybe even in the council they set up. The next thing that is on the agenda of the Department of Energy really are pushing LNG terminals, and they recently just approved on the 14th the Commonwealth LNG project in Louisiana. So they're moving ahead on that. FERC, as I said, the two big matters going on there in my book are resource adequacy and co-location of large loads. There's a resource adequacy conference I believe it is in June, and there's a proceeding going on right now about co-location of loads, meaning when you build these data centers close to a grid with the generation, who's going to be responsible for all the costs? And that is a thicket of issues. It has federal versus state implications, and consumer versus, the individual consumer versus the industry issues in terms of who bears the cost. So you've got allocation issues, load integration issues. Then we'll go on. I think the next thing, it's this independent agency, and we've already talked about that. NEPA, we've talked about their compliance with NEPA, and we talked about the city of Port Isabel and how the court or the FERC asked court to bring that case back to FERC because the guidance of under the Environmental Justice Act provisions no longer applies under CEQ regs. So the next agency, I guess I would focus on Interior. A big issue there, Outer Continental Shelf. They've removed the restrictions there. It's going to be interesting to see how they incent people to invest there. They've also taken steps to unleash Alaska's resources. And finally, he's issued an order that I've talked about before about unleashing American energy that has he's supposed to come up with a plan that the House and Senate are already interested in. And then the next one is your Environmental Protection Agency and Lee Zeldin.
Yeah, I think that's right. I think my theme here with Mr. Zeldin is going to be just the avalanche of backlash once the employee cuts are announced. At the same time, the regulatory changes are going to be announced, and that's all going to be happening in the March and April timeframe. So yeah, it remains to be seen. And then if the news today is correct, Dick, about the revocation of the endangerment finding for carbon, that's gonna trigger a a battle royale. I don't know how else to put it. It's going to gather all the players from every interest group in every corner of the environmental lobby to challenge that decision if that's going to be the direction they're going to go. And so I know that's the rumor, but once they step into that muck, it is going to be a tough one. It's going to take up a lot of their time and energy. So we'll see if they carry through on that threat.
Okay, let me just say that we talked about a few agencies. Obviously, these issues cut across many. Treasury is going to be grappling with the tax credits that were there under the Inflation Reduction Act. That's going to be a big issue. Congress will be dealing with the same thing. You saw Treasury rolled out Iranian sanctions or more sanctions on Iran or people who transported their oil. And the Department of Transportation is basically involved in this too. They've decided that they're no longer going to use social cost of carbon in the estimates of its analysis. So I guess we're coming towards the end, but this energy agenda and the environmental agenda for the Trump administration is going to involve every agency, and you're going to see things. This slide presentation will change tomorrow. So if you have any other final comments, Fred or Rich?
Yeah, let's grapple with a couple of harder questions there, which tough to answer, but we should. That's why we're paid the big bucks, right? So the question is the likelihood of fully funded contracts through the Inflation Reduction Act and the bipartisan infrastructure law being released, since canceling those funds would be a violation of federal contract law. I'd also add potential violation of the Impoundment Act. My take on this is this. I think ultimately that will not succeed. If there's obligated grants, money that's been distributed, that Congress said should be distributed, that money will have to be sent out. I think
that's right. If they've complied with everything and the clawback, that might be very difficult.
Again, and even though Congress has been quiet so far, I don't think the Supreme Court will be. I think the fundamental premise of Congress's role as the obligator of funds and then the votes that are taken and signed by a president, I don't think that can survive constitutional muster to say that a subsequent executive can just undo that vote. So my sense is that it's going to take a lot of steps to get to that point, but ultimately I think this effort to prevent funds from flowing that had already been obligated will not succeed. It may be different for funds that have not yet been obligated. So fiscal years 25, 26, where they haven't done the grant work, that could be a different dynamic. But for the stuff that's already been out there per the question, I do not believe they're going to prevail.
Yeah, as long as you're complying with whatever the terms are, and then each individual grant or situation may be different.
Correct. I think that's always to be stated. Someone asked, have we heard any rumors about the CEQ chair? No. And I've asked everybody, I've asked everybody I could, including people I think who interviewed for the job. And I'm wondering if the recent regulatory clawback might be a disincentive for somebody taking that job. But so far, no rumors about CEQ. But I'll let you know if I hear anything there. And then somebody asked, do we think it'll be environmental policy gridlock, or are we getting out of doing policy at all? And I think it's going to be a fair amount of gridlock, and that's because of the litigation. There's going to be proposals to rescind this or that and to stop taking actions. The other thing that's going to increase is citizen suits. In the environmental world, if the federal government declines to take action in enforcement and citizens believe that there's a gap to be filled, they can file citizen suits under a variety of environmental laws. And I think there's going to be an uptick in citizen suits because the federal government just isn't going to be in that business very much. So I do believe there's going to be a lot of gridlock and a lot of litigation coming out of it. And the last thing, reminder, the CLE code, Dick, do you remember what it was, Dick?
Yeah, it's environmental 2025, I think.
You were listening.
Yeah, I did. That's good.
You're unbelievable.
Environmental
2025 for your CLE credits. See what else was there. This is a hard one, Dick. Does a U.S. company have to worry about European compliance, and how should companies manage differences when there's a gap between what's going on here and what's going on in the EU?
Well, I mean, I think if you're practicing in the EU of operations there, you have to comply with what they have going on. And that's what I said before, may create some, issues with movement of product between the two. But I mean, I think companies deal with that all the time, because in the air industry and environmental and so forth, there are differences between the US and Europe.
Yeah, interestingly, in one area where I think there's actually going to be a more of a convergence, the SEC withdrew the greenhouse gas reporting requirement for reporting under, for publicly traded companies. California is pulling back on its proposal, and I even think EU is going to pull back on its. So there are certain areas, not all of them, there are certain areas where I think there's going to be more of a convergence on, deregulation, but not all of them. And I think your advice is correct.
And I think their politics is changing a little bit from country to country now too. So I think more remains to be seen on that one.
I think that's most of them that I read in the Q&A box, Dick.
Yeah, I think I think that's all. I don't. Rich, do you see any more?
I did not.
Okay. Well, we appreciate everybody attending, and hopefully this provided something useful to you. We will make these slides available sometime after the presentation, because I know at the end we especially flipped through them, some of those with the agencies and so forth. But again, what happens at the agencies is changing minute to minute. All right.
Thank you, everybody.
Hey, thanks, everybody.
Thank you.
See you.